Please be seated. Good morning. We are here today in case number CV18-272, munguia, is that pronounced right, versus cramer.
I say munguia, Your Honor.
Munguia, okay. Thank you. Munguia versus cramer. Counsel, each side has 20 minutes. Appellant may reserve time for rebuttal. I would just ask that you keep track of that yourself on the clock on the podium. The proceedings are being audio and video recorded, so if you could tell us who you are and who your client is, we'd appreciate it. We have read the briefs and discussed the case in conference. Please keep that in mind as you argue, and with that, you may proceed.
Good morning, Your Honor. May it please the Court. My name is David Abney, here representing Temi Munguia. I'd like to discuss the issues pretty much in order, the first one being the judgment NOV and new trial, then the biomechanical opinion problem, then the other collisions, the 2005 and 2011 collisions, and the last issue I don't want to talk about at all. I thought we briefed it pretty well, and if I manage to survive the first three and have time, maybe we'll touch on that. But the new trial judgment for motion JJMOL, it's pretty straightforward. You've got certain things to establish in a tort case of this kind: duty, breach, causation, and damages. Duty, there's nobody disputing about the duty to drive with care. The breach, my colleague in the answering brief is trying to say that there is a dispute about the causation, but when you rear end another vehicle in front of you and there's nothing unusual going on in front, no emergency braking, sudden stopping, anything like that, and the explanation is, well, it was just being careful by looking around other areas to make sure there were no problems in other areas, well, that really doesn't help you a whole lot when you slam into the vehicle in front of you. So I don't think there's really any valid issue on causation. Damages is a problem. The other side did admit to the most trivial kind of damages, a bruised shin, and Dr. Pelez was willing to go so far as to say some sort of muscular discomfort or that sort of thing. But you do have the four elements there, and if you've got the four elements there, then it's up to the jury to say, well, okay, it's not the biggest case in the world, but we find for the plaintiff, and we're going to award whatever the damages are under this kind of a situation, and that didn't happen. And I believe that was against the weight of the evidence and contrary to what the jury was supposed to be doing. And that's really all I've got on that issue, so we can move on to...
Jury, you're saying a jury can't come back and say the damages are zero? They caused an accident, but they didn't necessarily cause an injury.
Well, not when the uncontradicted evidence is that there is some injury, even if it's only a bruised shin.
A bruised shin is enough.
I know. And you'd expect to find it's...
Insatiable injury that your client was asking for.
Well, she was asking for a lot more than that. This is one of those cases where the damages start
This
low.
all revolves around the 2010 accident, correct?
That's correct.
And that was a very low-speed collision, as it
Correct.
were, that resulted in a small bruise to your client's shin.
And she alleged other injuries, but the one that the defense is willing to admit to, and their experts were willing to admit to, was a bruise on the shin. And I know it's not a lot. You would
You
expect...
have to reverse unless they've awarded at least 1 cent. Is that your argument?
Yes, I think so. Like I say, it would be nice if her leg fell off or something like that. Well, not nice for her, but if dramatic kind of immediate kind of injury. But this is one of those things where the injury seems to have progressed and become worse and worse, and eventually
what if
wind
the
up.
actual injury is 10 cents?
Pardon me, Your Honor?
What if the actual injury is hypothetical, 10 cents, and the jury came back with zero? Do we have to do the 11-day, 16-day trial?
I think it was 11 days, Your Honor.
That's the kind of reversible error we're talking about?
Yes, Your Honor. And issue number 2, if I may.
Sure.
I mean, that is a very technical argument, and I admit that. But the jury has a job to do, and if you fit all the slots, you do 1, 2, 3, and 4,
we
then you've got a
review in
case.
the light most favorable of sustaining the jury's verdict. You would agree with that?
Yes, Your Honor. But even viewed in that light, when you've got the 4 elements lined up, the slot machine kicks out, and you're done. The jury has a job to do at that point, and they didn't do it. The biomechanical thing is a fascinating problem. We have Dr. Pellis is a marvelous expert. I don't know if he ever appeared in any courtroom with you all, but he's a plaintiff's nightmare. He's just so believable, and he's an expert on anything you want to name. He's extremely smart, capable, but he's not a medical doctor. And what he's trying to do here, and what he did, was to provide a specific causation medical doctor kind of opinion, and he's not allowed to do that.
Well, how did he word his specific medical causation opinion then, counsel?
Well, I put the citations to the trial's transcript. Basically, he testified that the collision could not have caused Munguia to suffer any sort of significant injury. In the answering brief on pages 11, 14, and 26, and especially on 26 when they talk about the issue presented, the other side puts it this way: did Logan's biomechanical expert, Dr. Pellis, properly testify that the forces involved in the accident could not conceivably have caused Munguia's 2 herniated discs? And he said, and that's a medical opinion. It could not have caused this. The forces in this particular accident could not have caused this particular person to have suffered these particular injuries that she's complaining about. That is a medical opinion. Now, what he did in the Lohmeyer case, and what other biomechanical experts do that passes muster, is to say, well, I don't see a mechanism of injury here where the typical person would suffer an injury. And there's a difference, though, between that, just saying I don't see a mechanism of injury here, as opposed to saying this particular person could not have suffered an injury in this particular accident that they're complaining about. You can do one, you can't do the other. Cases from across the country deal with this sort of thing. And I know Dr. Pellis he's a Renaissance man in many ways. He has a smattering of education in as many fields as you care to name. But that's not enough to make him a medical doctor. We had that Combs case I cited from Virginia in 1998. The expert testifying there had completed all the academic work for a medical degree. And the court said, no, that's not enough. You're not a medical doctor. And the difference is every person who comes into an accident or collision is different. Their age, their weight, their physical structure, and ailments that they may have had. All these things combined, you need an actual medical expert to say this particular person could have or could not have suffered an injury in this specific accident. That's what you need, and it has to be a medical doctor that does that. That's our position anyway, and it's supported by cases from across the nation. The third issue is about bringing in these other collisions. The purpose at trial.
So how do you envision these affidavits from, what are they called, collision experts? Or
Biomechanical expert.
They're biomechanical, okay. So let's say we have one that is permissible under your argument. How far can they go?
As far as he went in Lohmeyer's, as far as you can go. You can say.
So what is that?
In my opinion, there is no mechanism of injury in this particular case, and that's it.
How is that different than what was said here? Just the reference to discs?
Here he said, and several times, and they stressed it in the answering brief, there's no conceivable way that she could have suffered the injury she's complaining about, the herniated disc. No way she could have suffered that injury. This person,
That's
this
significantly
accident.
different than there's no mechanism by which
Yes.
an injury could be caused.
One is a general opinion. In general, there's no mechanism here that would result in an injury, and the other is this particular person absolutely did not suffer an injury in this particular accident.
Based on the mechanisms in the collision.
Well, you can go on and add frills and embellishments to it, but the opinion that is the problem is to saying this specific person, this specific accident, this specific injury, it could not have happened. You cannot say that as a biomechanical expert and get away with it, unless you're also cross-trained as a medical doctor. And
He also said we have a hypothetical person who is age of your client, all the same facts. Under that hypothetical situation, there couldn't have been an injury. That's okay.
That skates on the line, but it's okay.
It's naming an individual, as it were.
This particular person, this particular accident, this particular injury, if they all line up like that, you're giving a medical doctor kind of opinion. You're not giving a permissible biomechanical expert opinion. I know it's a
So
fine
Dr.
line.
Pellis said there would not be a mechanism of injury or a force level that would produce disc herniations of this accident. That's inappropriate.
Could you repeat that? I think I heard the mechanism word in there, and I think that would make it okay, but I'm not sure.
I'm looking at it. I can't give you exactly where it was in the record, but I believe there's a quote from Dr. Pellis that he said, quote, "There would not be a mechanism of injury or a force level that would produce disc herniations of this in this accident." Is that appropriate?
That's a specific causation opinion. And
That is
this
inappropriate.
specific, that is not appropriate. That's a specific causation opinion.
Well, he's talking about mechanisms of injury and force levels. Isn't that appropriate?
But he went on to talk about this specific. I think that the language you used was tighter than simple mechanism. And in other places, he said, no way that this could have conceivably happened.
So that quote I just gave you, make it within the law, in your opinion?
I think you said it's not within the law to say disc herniations, but it is okay to say.
Based upon my examination of the events and the circumstances, I do not see any mechanism of injury in this particular case for a person with the general characteristics of this particular person. You could probably go that far.
How about
You cannot go further.
Isn't that just
Five-
semantics, counsel? I
No.
mean, that's 6 of one, half dozen of the other.
It's close, but it's not. And sometimes semantics count for an awful lot. In this particular case, if you're saying this specific person, this specific injury, this specific accident there could not have been the injury that the person is complaining about, that is a specific causation opinion, and you
just say
cannot
could
do
not
it.
cause disc herniations in anyone. Then that's okay. You just generally, this would not cause a back injury. This level of force in anyone. And this particular person might have a history of something. It may have caused an injury. But if you're just saying this was not enough of a mechanism to result in a back injury. If you're just saying, you seem to have said that it's okay to say there's not enough, the mechanism did not create an injury, that's okay.
You can give a general causation opinion. I laid that out pretty well in the briefing. General causation opinions you can give. Specific causation, this person, this
That's
injury,
what I'm
this
trying to get at,
accident.
though.
You can't do.
Is it still a general opinion if you're just saying this wouldn't cause a back injury in general? Not necessarily this person, but I don't see any mechanism that this seat would somehow do something that would cause a back injury.
Right. You could get away with that. You have to keep it as a general causation opinion. It's a fine line. He kept to the right side of the line in Lohmeyer. Very carefully kept to the right side of the line. This time he did not.
what if he said, we have a claimant, John Doe, and she was driving in a Jeep, and she was hit at 5 to 7 miles an hour. If I assess that, generally, there's no possibility here. Under that situation, take it for what you will in this case, but there can't be an injury.
And if you say in general, there's no mechanism of injury, you're okay. If you say this specific person, this specific accident, this specific injury, you get specific causation opinion, you cannot do it as a biomechanical expert, unless you're also a medical doctor. There's a few of those guys around, but he's not one of them.
And can you point us to the specific wording that you're saying was improper here?
Well, when I sit down, I'll dig up the ones, but it's I think it was pages 41 and 42 in the opening brief, if I remember where it was, but it's also right in their answering brief. They paraphrase it, could not conceivably cause, and that's really what he testified to. But it's in the briefing. He's a marvelous person. He talks a lot. He was there on the stand for about an hour. He gives all kinds of opinions, all kinds of shades, but the specific causation opinions are there, and they're deadly in a case like this, where so much depends upon, well, did it really cause all these injuries that you say it did cause? And he's firmly on the side of the church going, hallelujah, it certainly could not conceivably cause this particular person to suffer these particular injuries. Could not do it. And that may have been enough to tip the scales. You never know. And of course, you never know about people. People are so different. I was reading a case the other day, I think it's called Papastathis, about a poor gentleman at 7-Eleven bending over and he gets hit on the head by a Coke can, comes down from on high, hits him, and he ends up dying because of a cranial injury. You just never know what's going to cause people to suffer their injuries and what sort of consequences is going to be. That's why you need to have a medical doctor giving these kinds of opinions, not a biomechanical kind of guy who's just dealing with generalities. As far as the 2005-2011 accident mentions, if I can shift to that, what was happening at trial was the defense was stressing the fact that, well, we had an accident in 2005, we had this more significant accident in 2011, and that's really the cause of all the problems here. Now they're backing away from it on appeal, and I don't quite understand what they're saying, something about credibility, or I'm not quite sure. But at trial, it was causation, and it didn't make a lot of sense, especially when you got to the closing argument. They harped on the 2005 accident, although earlier they had told the court, well, we're not going to talk about the 2005 as far as causation. And the 2011 accident, their own experts, Dr. Pellis, the biomechanical guy, and Dr. Merrick, their medical expert, both said, we are not giving any causation opinions about the 2011 accident. So there they are arguing about causation like crazy to the jury, that, well, it's really this 2011 accident. They even threw in the 2005 accident at the end, even though they said they weren't going to do it. And that's really the cause of all that happened to her, because it was a major accident. But they don't have any testimony to back it up. And I don't think you can do that. I suggested to the court that really what you're doing is violating the non-party at fault system, and you are. You're holding out. Well, there's other people who are at fault. Whoever caused the 2005 accident, 2011 accident, they're really at fault. So all or most of what she's complaining about was the 2005 and especially 2011 accident.
Well, okay, the trial court gave, I think, a motion in limine instruction regarding the 2005 and 2011 accidents. And subject to trial objection, the existence of those accidents and any injury that may have occurred from that impact the plaintiff's medical condition. That was the kind of the frame in which the court ruled that the parties could bring up, or I guess the plaintiffs could, or the defendants could bring up the 2011, 2005 accidents. How was that ruling violated at trial?
Well, the ruling is wrong. It's talking about, you can talk about it in relation to her medical condition. That's causation. You're saying that 2011 has an effect on her medical condition. That's causation.
And you're saying that's improper?
That is improper because...
Why would you not be able to say she's complaining of back pain, but the previous accident didn't cause back pain? Sure, back pain is from a 2011 accident. You're saying that's not admissible?
Where's the evidence? Their experts backed away. They backed out of the room, saying we're not going to give an opinion.
The ruling ahead of time, though, saying that I'm going to admit it for the purpose of showing that your injuries were caused by the 2011. You're not taking issue with that pretrial ruling.
Well, yeah, because you can't do it without expert opinions, and there weren't any experts. Their opinions fled from any notion. Well, we're not going to talk about this 2011 causation. We're just not going to do it. So how can you go forward with that sort of no evidence?
What was the reference then to the 2011 accident? How was it raised?
Well, all the major witnesses were questioned about it. Every single one, over and over, about the 2011 accident. And then in closing, they harped on the 2011 accident. This is the real cause of everything that happened. So it was part of the fabric of the case, and it should not have been there.
And you're saying you would absolutely have to have an expert if you showed some major accident, rear-ended, going 80 miles an hour, you couldn't bring that up without an expert? Is that?
You need an expert. I mean, they had great experts. I mean, they're very accomplished experts, and they both said, we're not going to talk about causation.
Did your client talk about the 2011 accident?
Defensively, yes. Once the ruling was in, what are you going to do? You're going to have to say, well, the 2011 accident.
That raised the issue now of credibility on her part?
No.
I mean, she's saying that it's specifically the 2010 accident that caused my injury. But now we know, and I know you lost that ruling, but now the 2011 accident is out, and she's saying, no, it wasn't a 2011 accident, it was a 2010 accident. Can't you bring up that? Isn't it relevant to go to her credibility?
No. She's not a medical expert. She says, as far as I'm concerned, it was a 2010 accident. That's what I'm here about. I'm not here about the 2011
Okay, well,
accident.
I mean, that's her position, but isn't it fair game in cross-examination to bring up the 2011 accident? Subject, I mean, taking calculus your objection to the court's ruling. I mean, isn't it just simple relevance?
No. If she were a medical expert, sure.
And how about if she?
But once she said no, you can't keep going. I mean, they did. They kept going and going. Every witness, over and over. 2011, 2011.
How about if the evidence is after the first accident, I wasn't in any pain, I didn't report my pain to anybody. The evidence, not necessarily medical testimony, the evidence was after the 2011 accident. She told a bunch of people she was in pain. Does that become relevant? The 2011 accident, when she said she didn't have any pain after the accident issue here, but after the 2011 one.
After the 2010 accident, she says, hey, everything's fine, kind of no harm, no foul, and walked away. But she does, to Judge Catani's point, after the 2011 accident, have a host of issues, physical issues that come into play.
If you're going to try to tie those in, if you're going to try to exclude and say everything is related to 2011, or try to tie it into 2011, or exclude from 2010, you've got to have expert opinion evidence. You can't just sort of slough it in based upon what she is complaining about. You've got to have something to back it up, and they didn't have anything. I'd like to reserve my remaining 12 seconds.
Do you have a citation for that?
I'll take a look at my brief.
Case or statute or rule?
Yeah, that medical expert testimony is mandatory.
Right. It's
What's
irrelevant.
your authority to that?
Yeah, I will take a look at it.
Unless you have.
Sure.
Yeah, right. Thank you. Counsel?
Good morning, Your Honors. My name is Christopher Robbins, here on behalf of Courtney Cramer, who has since married and taken the name Logan, and I apologize for any confusion by using her married name, but that was in deference to her. I'm here with my partner, Tom Hall, and Diane Lucas, who were the trial attorneys in this case. Judge Bean, first to answer your question, the citation, there would not be a mechanism or a force level that would produce disc herniations in this accident, is at page 134, and it's in the trial transcript for January 30, 2018.
Well, okay, since I appreciate that, but I guess Mr. Abney would say that your witness stepped over the line when he said it would cause disc herniations in this case.
No, he said this would not conceivably cause disc herniations in this case. He said right above that, I don't believe there's first of all, on cross-examination he was asked, so are you talking about the cause of Ms. Munguia's disc herniations? And he said, no, I'm not talking about that. And that starts on page 133. He says, what I'm saying is, I don't believe there's a mechanism in this accident for these injuries. On page 167, he goes back again and specifically says, I am not rendering any opinion on Ms. Munguia's medical condition, what might have caused these disc herniations. I'm not talking about that. I am just telling you, as a matter of accident reconstruction and biomechanical engineering, that there is no mechanism or force level in this accident that could have caused those. And guess what? That's exactly what happened in Lohmeyer. Let me read you from paragraph 21 of Lohmeyer. This is a court speaking. Dr. Pellis conducted a reconstruction of the accident and a biomechanical analysis of the forces involved, concluding that the accident could not have been the cause of William's alleged injuries. William was the plaintiff. Mr. Abney is unhappy with Lohmeyer, but it's been the law of the state since 2006, and there's no reason to disregard that. Dr. Pellis has been doing this for years, obviously, because Lohmeyer involved Dr. Pellis, not only the exact same issues, but the exact same expert. And the court affirmed what was done in that case, which, by the way, was a a defense verdict in a rear-end car accident. Lohmeyer is just dispositive here, and I know Mr. Abney doesn't like the result, but that's the law of the state.
Did your client concede this shin bruise?
I believe Dr. Merrick said, yeah, she. And in fact, Dr. Merrick and Dr. Pell said, yeah, she might have had a shin bruise.
Might
Or I think they did. I think they said.
Let's assume they did.
She did. Okay, assume they
Is
did.
it possible for the jury to come back with something south of 1 cent in damage?
What Dr. Merrick said is, let me get this exactly. He said that there's no treatment for a bruise. You bang your leg, you say ouch, you wait a few days, the bruise goes away. There's no treatment, and consequently, he didn't say this, but consequently no damages. There were no damages here. And beyond that, there's overwhelming evidence presented to the jury, and the standard of review is just dispositive in this case. It's an 11-day jury trial. They thought so little of Ms. Munguia's claim and of her witnesses that they returned a verdict in 40 minutes. They came back with a complete defense, unanimous verdict. We don't know exactly what they decided, but we do know, and we went to great length to put this in the answering brief. They had substantial evidence that Ms. Logan, our client, was not negligent in her driving. That Ms. Munguia was not injured in the accident, that this minor rear-end accident could not have caused 2 herniated discs.
So, counsel, is it possible not to be negligent if you rear-end somebody? That's not a per se claim?
It's not. Mr. Abney wants it to say absolutely. Not only is it a presumption, but he leads on to say it almost is a certainty that if you were the second driver in a rear-end accident, that you're at fault. But that's not true. Lohmeyer is an example.
Lohmeyer's the authority?
Lohmeyer is an example for that, and I'm sure we could come up with other cases as well that say that there.
Say that you're not at fault for running into the person. It's saying that did not provide a mechanism that created an injury.
This is it's curious, Your Honor, because in Lohmeyer they actually admitted negligence. So even after admitting negligence, the jury still returned a defense verdict. In this case, we did not admit negligence because we don't think she was negligent. As Ms. Munguia herself said, as she walked back to talk to my client and her future husband, she said accidents happen.
Yeah, but
then she walked back to the car.
Strict liability doesn't consider that.
Drives it away. I'm sorry, what?
A strict liability theory doesn't assess the dialogue that takes place around the accident.
No, there's no.
You look at the claim, and it's either liable or not. There's negligence.
And the jury said no.
And so it's not a statute. There's no statute out there that says this is a strict liability crime or common law or.
No. But
the jury could have been saying you were negligent in hitting someone, but they didn't cause any damages.
Exactly. We don't know what the jury decided. It was just a defense verdict. They could have decided no negligence. Maybe they decided there was negligence but no causation. Maybe they decided causation but no damages. I mean, she had more medical treatment than I even thought was possible.
Could I ask about the 2011 accident?
Sure, absolutely.
What was the point? What was the argument that your client made regarding the 2011 accident?
There were actually a couple of things, Your Honor, and the prime one is credibility. Ms. Munguia never told her own doctors about this second accident. It only came up because she finally mentioned it to the defense expert, Dr. Merrick. And so we questioned her about this, and it turns out that as they concede in the opening brief at page 45, The second accident was a violent crash that caused major damage to the same Jeep involved in the November 4, 2010 collision, which is the one we're
But
here
was there
about.
some testimony from your client that that's more likely to have caused an injury than the 2010 accident?
No, what we were primarily we were talking about Ms. Munguia's credibility.
I read the court's order as saying this is admissible to show that her injuries resulted from the 2011 accident.
Oh, and I don't think
Is that an incorrect reading of that?
I don't think if that is a correct reading of that particular order, my partners didn't go there. They were just talking about, doesn't the jury have the right to know you're claiming all of these injuries in November 10, 2010, excuse me, November 4, 2010. You have a much more significant accident 5 months later that you never tell anybody about, including your spinal surgeon. You're diagnosed with 37 diagnoses, many of them overlapping what happened in this accident. Somehow, doesn't the jury want to know that somehow you miraculously recovered from the second accident that was more severe, but you're still having all of the same symptoms from the first accident? That it stretches credulity, and the jury recognized that that it really went to credibility, and it also went to damages, because how nobody ever separated anything out.
So it does go to the injuries. It's suggesting that the injuries were from the 2011 accident.
Well, we never, we were not claiming that she was injured as a result of that May accident. We were claiming she wasn't.
Claiming that when you're saying she should have told her doctors about that. It was a violent crash in 2011, and that's more likely to have caused her problems than the 2010 accident?
No, because we're saying she had no problems as a result of the 2010 accident.
But
she had no
were you
injuries.
saying she had no problems at all? That
she had no problems at all, other than a
period
bruised
even after
shin.
the 2011 accident.
Excuse me?
Was the argument at trial that she doesn't have any injuries at all, whether from the 2010 or 2011 accident? Was that the position?
Yes.
Okay, so that was why it
it
wasn't necessary to necessarily go into her injuries were caused by the 2011 accident, because in your client's view there weren't any injuries even after the 2011.
I'm not even sure I'm not even sure anywhere I'd use the word cause in regard to that accident. They asked the facts about the accident to establish that here was a significant accident that happens after the one. I mean, it was like a T-bone accident. She hit her head on the windshield. There are, other things going on. A more severe accident after the accident, you're trying to collect millions of dollars from our client, and yet you never mentioned it. And somehow, whatever injuries you received in that accident, if any, somehow you were able to recover from those, and yet injuries.
Was she saying that all of the injuries from 2010 had been resolved? And
no, we're saying she was never injured.
But I'm trying to get at what her position would be if you're suggesting that she's saying she recovered from 2011 accident, but she still has injuries from the 2010 accident.
That's apparently what she was saying. She was trying to sell that to the jury, and the jury didn't buy it. But it was a very insignificant. I mean, it's there, but it's a very insignificant portion of this.
You had
this case.
said, I think you said, wouldn't I don't want to paraphrase. Wouldn't you want to know about this, the 2011 accident? In your argument, you said that.
Yes.
Why would you want to know? As the jury, why would they want to know? As you said.
For exactly this reason is. She's claiming millions of dollars from a minor rear-end accident. I mean, this was so minor that Ms. Logan's car just sort of slid under the back, the bracket and the
Right, we're
and the
talking
wheel.
about the 2011 accident now.
Now the 2011 accident is like, why wouldn't she say anything about that to her own doctors?
So it's only
The
the
doc,
not
for example-
saying to her doctors that matters. If we take that single fact out, then it's irrelevant.
Well, I suppose we could have, gone deeper into that and determined causation and what exactly her injuries were and everything. But the only thing that we're trying to say is, primarily that this woman is just not credible. It's like you're going into for major surgery, you're going into spinal surgery, and she didn't even tell Dr. Estashami about this.
I understand. So you're
she
saying,
did-
wouldn't you want to know
Yeah.
that this happened and
In
she didn't
between.
tell her doctor? Not,
Right.
wouldn't you want to know that this happened? A far more serious accident within 12 months of our accident.
Did she tell her doctor, though, that she went in before the surgery that this was caused by a 2010 accident? Or was there
Well,
any
we
discussion?
don't. Our understanding is she just told her surgeon, that she had an accident. Didn't say which accident. Didn't say she had an accident. And I apologize. I cannot point a precise spot in the record as I did with this other, but it's like this is. We were involved in a case called Rivers versus Sully some time ago, and in that case, it was a failure to disclose an accident, and it was just very curious that the plaintiff was involved in 3 accidents, and the 2 of which he was not at fault, he mentioned and disclosed, and the one that he was at fault, he didn't. We're not saying there's a disclosure problem here. We're just saying this goes to credibility and whether in fact she actually had any damages as a result of the 2010, not what happened here, but whether she could have had any damages if she could have been in a serious accident afterwards and recovered after, I forget whether it was chiropractic care or what other care, but it just strains credulity, and that was the big issue, credibility. This is a woman who claims, 8 years after this accident, that she's in such pain that she can't even appear every day at trial. She's in such pain, and I was trying to go through, and I was talking to my partners, and there's just such overwhelming evidence in this, and I know Your Honors will have the opportunity to read the transcript, but was there just one piece of evidence that was so overwhelmingly supported the jury's verdict, and here's a really good one. She had an MRI on July 29, 2015 at Marcus Diagnostic Imaging, and that's part of Trial Exhibit 182. And the MRI shows that the spinal surgeries repaired the herniated discs. So she no longer has any physical problem, any physical evidence whatsoever. And yet for 3 more years she complains that she's in such pain despite every medical treatment conceivable, including spinal surgeries. She's in such pain that she can't even appear at her own trial.
You're saying people can't have pain after a surgery corrects a problem?
If not if the pain is allegedly the result of herniated disc and you repair the herniated disc. I suppose you can have pain for other reasons, and I don't know about you guys, but I'm getting older, and yes, I feel pain occasionally, but nothing that resulted from the November 4, 2010 accident. Your Honors, there was just overwhelming evidence to support this jury's verdict, and we don't reverse for Rushin. And so unless the court has further questions, I'll just ask you to affirm the jury verdict and the resulting judgment.
Thank you, counsel, for your argument. Mr. Abney?
I don't know if we have any time left.
As a frequent, well, I wouldn't say that. As a frequent practitioner, you have a minute.
I'll do the best I can. For the proposition that there is you need expert testimony to prove medical injury, it'd be Yates versus Industrial Commission, Yates, Y-A-T-E-S, 116 Arizona 125, page 127. I cite that at page 49 of the opening brief. Also to the same effect as Bell versus Maricopa Medical Center, which is also cited on page 49 of the opening brief. As far as Dr. Pelle's specific causation opinions, page 32 of the opening brief, I cite all the areas in the transcript where he did that, so they can be specifically hunted down. The closing argument materials concerning causation are pages 46 and 48 of the opening brief, and I have a nice block quote on page 48 where the defense counsel is just hammering on the 2011 incident. But throughout the closing argument, there was a whole lot going on. I think that's it. Thank you very much for your patience. I appreciate it.
Thank you, counsel.
counsel.
Thank you both for your argument, and we will take it under advisement, and we are adjourned.